State A ratified the International Convention on the Protection of Cultural Heritage.
And upon ratification, State A made a reservation to exclude some key provisions regarding enforcement mechanism and also dispute settlement.
The treaty itself actually contains a clause which limits reservations, and so several states had objected to this reservation. As you can imagine, State C, State B, State D, and the list went on and on.
Arguing that the State's A reservation undermines the purpose of the convention.
Hello, good evening. Is this Miss Mayang?
Yes, this is Mayang speaking.
Alright, thank you so much for taking this call. Thank you for your time. My name is Shasha and I'm part of the research team behind the documentary The Reservation That Shook the Convention. We are currently filming episode 3, and before we begin, I would like to inform you that this conversation is being recorded solely for academic and documentary purposes. So may I have your consent to record this call and to include your views in the documentary?
Yes, I consent.
Thank you so much. Alright, so in the previous episodes, we have explored how treaty reservations are made, and what we haven't addressed yet is their impact. So from your perspective, Ms. Mayang, what was the core issue with this particular reservation?
So in my view, the issue is actually whether State A's reservation to exclude the application of the several key provisions relating to the enforcement mechanisms and also the dispute settlements is an allowed circumstance and valid under the law of treaty or not.
I see. Alright, thank you so much, Ms. Mayang. Your perspective adds an important dimension to this story. Okay, just to reconfirm, are you comfortable with your opinion being included in the episode 3 of this documentary for educational purposes?
Yup, I'm okay with that.
Glad to hear that. Thank you for your time and for helping us understand why this reservation truly shook the convention. Right, goodbye. Have a good
Thank
evening.
you so much. Goodbye.
Under the Vienna Convention Law of Treaties, the definition of reservation is governed under Articles 2, Clause 1, Clause D, whereby it states that a reservation is a multilateral statement made by a state when signing, ratifying, accepting, approving, or assenting to a treaty and wish to exclude or modify the legal effect of certain provisions in the treaty in accordance with its domestic needs. By virtue of this article, a state is given the opportunity to ratify a treaty, but at the same time, a modification can be made to its own will. However, this discretion is not absolute, as Article 19 of the Vienna Convention Law of Treaties provide the conditions for a reservation to be valid. Particularly, a reservation is not permissible where, Clause A, the prohibition is prohibited by the treaty. Clause B, the treaty provides that only specified reservations which do not include the reservation in question may be met, or Clause C, if the condition in Clause A or Clause B is not met, the reservation is incompatible with the object and purpose of the treaty. This principle is affirmed in the case of Bellilos and Switzerland, where the court considers Switzerland's interpretative declaration, which in substance amounted to a reservation, is invalid under Article 64 of the European Convention of Human Rights, as the interpretative declaration is too broad in scope and did not meet the requirement for a permissible reservation of the provision. Thus, the court overturned the trial in Switzerland and upheld the applicant's claim.
In addition, the Vienna Convention on the Law of Treaties governs the acceptance of an objection to reservation under Article 20. Once a state has entered a reservation, other contracting states may either accept or object to that reservation. Under Article 21, where a reservation has been expressly authorized by the treaty itself, then acceptance by other contracting state is not required. However, under Article 22, it provides that in certain circumstances, particularly where it's appear from the limited number of negotiating states, or from object and purpose of the treaty, that the treaty must be applied in its entirety, a reservation only be valid if all the contracting states accept it. Furthermore, based on the Article 25, where a state does not raise any objection within 12 months after being notified about the reservation, or by the date on which it expressed its consent to be bound by the treaty, it is deemed to have accepted the reservation. Additionally, Article 24 explains the legal relationship between a receiving state and other contracting states in cases not covered by the previous paragraph. Under Article 24p, an objection by another contracting state does not automatically prevent the treaty from entering into force. For the treaty relationship to be excluded entirely, the objective state must clearly express its intention to that effect. By virtue of Article 24C, a state consent to be bound by the treaty becomes effective as soon as at least one other contracting states accept the reservation.
So now let's look at Article 21 of the VCLT. So what does Article 21 says? This article defines the legal effects of reservations and objections to reservations. So pursuant to Article 21 of the VCLT, the legal effects of a reservation depend on whether it is accepted or objected to by other states. Under Article 1, Clause 1, where a reservation is valid and accepted by another contracting state, the provision of the treaty to which the reservation relates are modified in the relations between the reserving state and the accepting state to the extent of the reservation. Correspondingly, the provisions are modified for the accepting state in its relation with the reserving state. However, under Article 21, Clause 2, such a reservation does not affect the treaty obligations between the other parties interstate. Further, Article 21 Clause 3 provides that where a state objects to a reservation but does not oppose the entry into force of the treaty between itself and the reserving state, the provision to which the reservation relates do not apply between the two states to the extent of the reservation.
I will now be moving on to the application for question 2. As previously mentioned, Article 2, Clause 1, Paragraph D of the VCLT allows State A to be at liberty to make a reservation of the treaties that it ratifies for the purpose of their own domestic interests, but this is subject to the exceptions that are laid out in Article 19. Because the treaty itself contains a clause that limits reservations, it might be argued that the second exception could be invoked because the treaty has a specified reservations regarding a clause that limits reservations. However, it is not clear as to whether the clause allows but limits reservations pertaining to enforcement mechanisms and dispute settlement. So therefore, the most applicable exception is the third exception, which is that the reservation is incompatible with the convention or the treaty. And in this situation, it is the Convention on the International Protection of Cultural Heritage. And as we can see here, as I have laid out, this is Article 19 of VCLT, and as per paragraph C, you can see the third exception. Next, the treaty that was ratified by State A concerns the protection of cultural heritage, and it also contains a clause which we know, which limits the reservations. And State A's reservation is to exclude the application of provisions that are related to enforcement mechanism and dispute settlements, and this is arguably very fundamental to the treaty's convention and the purpose. This is because the enforcement mechanism may impose an obligation onto the states to implement protective measures so as to prevent destruction or neglect of cultural heritage, and thus this is a vital provision in the treaty. Similarly, the dispute settlement provisions are also of equal importance, and they are needed to achieve the purpose of the convention, which can allow peaceful methods for any states to resolve disagreements regarding the convention's interpretation or any alleged breaches. A very simple example is that in such circumstances, State A can simply say that they are not a party to the convention for the objecting states, and thereby they are able to avoid responsibilities and frustrate the purpose and the object of the convention. So for State A to make a reservation on the dispute settlement provisions, it would cause significant difficulty for other states to cooperate with State A if there are any international disputes, and also it might even create a lengthy process to resolve such disputes. Hence, the purpose of the convention would not be met. As per the principle affirmed in the case of Bellilos and Switzerland, State A's decision to make a reservation on the enforcement mechanism and dispute settlements is too vague, and it risks undermining the purpose of the convention. Hence, it is not a valid reservation as it falls under the third exception where a reservation cannot be made as per Article 19 of the VCLT.
Although State A entered a reservation upon ratification, the Convention on the Protection of Cultural Heritage limits reservation and does not expressly authorize State A reservation within the meanings of Article 20, Clause 1 of the Vienna Convention on Legal Treaties. The implication of this limitation is that the validity of the reservation must be assessed under the subsequent provision of Article 20. Based on this implication and considering that the convention concerned a collective effort for cultural heritage protection requiring a uniform enforcement and dispute resolution among all states, Article 20, Clause 2 of Vienna Convention on Law of Treaties is applicable, such that acceptance by all contracting states is required. However, several states have expressly object, thereby preventing the attainment of unanimous acceptance. Where Article 20, Clause 5 of the Vienna Convention on Legal Treaties on implicit acceptance does not apply where objections are expressly made, and Article 20, Clause 4 sub B and sub C do not automatically preclude treaty relations, the implication of Article 20, Clause 2 is that this provision cannot override the requirement of unanimous acceptance. Accordingly, State A reservation is unlikely to be valid, given the objection raised and the nature of the conventions.
Now, regarding the legal effect of the reservation, in the event where there is a valid reservation by State A, there would be significant change with the relationship of State A and other states that are parties to the convention. As per Article 21, Clause 3 of the VCLT, the relationship between State A and the other states who object would be modified as the provisions relating to the reservations would no longer be applied between the two states. And for the other accepting parties, the related provisions are modified in the relations between State A and the accepting states by virtue of Article 21, Clause 1. However, as we have argued, State A has not made a valid reservation in the first place. Therefore, the relationship between State A and the objecting states would not be legally modified.
So in conclusion, State A's reservation to exclude the application of several key provisions regarding enforcement mechanisms and also the dispute settlements is an exception to Article 19 of the Vienna Convention of the Law of Treaty. Because of that, State A is prohibited from entering a reservation into the treaty, and subsequently, the reservation is not valid under the Law of Treaties. So what's coming up in episode 4? Stay tuned!